In a damning indictment of Public Protector Advocate Busisiwe Mkhwebane, the Pretoria High Court has set aside her entire CR17 Bosasa report. A full bench of judges criticized Mkhwebane's knowledge and application of the law and found her remedial actions to be invalid. The judgment is a victory for President Cyril Ramaphosa, who approached the court to overturn the report into his election funding. We're joined now by Bulelwa Mabasa, who is a director at Werksmans Attorneys, to unpack this. A very good evening to you, and thank you so much for speaking to us. I said quite a scathing finding, especially when somebody at that level and that particular office whose knowledge of the law or application thereof is questioned.
Absolutely. I think the premise of this must start off with saying that the reason we have an appeal system is that the law takes into account that no one is infallible and that public officials can reach decisions that could be appealable. But I think this judgment goes further than that. It is just not an issue of a public official, or rather an office, having made an error, that it goes beyond that, it puts into scrutiny, into question, the ability of the office to look at evidence before it, make the right decisions based on that, and also the understanding of basic tenets of the law. Because if you think about the first issue that was meted in the judgment, was the fact that the public protector mistakenly relied on an incorrect section out of the legislation, of her own legislation. So here, I think we're talking...
Which is a very important point that you make, because I want to understand that she has often pointed out the fact that she, as an individual, is not the office of the public protector. And I think for those who don't understand the legalities of how the office works, if a judgment such as this then accuses her of lacking an open mind and... It somehow implies prejudice on the part of the public protector, but surely as an office there should be some way of, seeking consultation or accepting a different point of view.
Yes, I think it's important to understand that there's the office of the public protector as an institution, and then there's the public protector personally. This case brings into question issues around the public protector's own understanding of the legislation that governs her own office, and her ability to interpret the law, her ability to look at the facts before her and to weigh in the evidence that is before her in reaching conclusions. So whereas we can say that this is about the competence of the office, if you look at it in the light of the Constitutional Court judgments, for example, that was as scathing, together with this one and others that we've seen, that we can correctly, I think safely point out that the Office of the Public Protector is not at its best shape at the moment. So
it seems to, from what you're saying, what the courts are implying, that it's a one-man office in the sense that, and pardon the gendered term of that, but I mean, one would think there's a deputy public protector, and then there's the office which has skills within it that should be in a position to help her make such decisions, especially when the court points out the fact that there was a changing of the wording of the Executive Ethics Code, which legislates against willfully misleading Parliament or deliberately, and what that means.
Yeah, sure. I mean, it's got to be a team effort. As you correctly pointed out, there's a deputy public protector, but over and above that, there's an additional buffer. And those are the legal representatives that act on behalf of the office. So to have such a fundamental question of law that contains such unfortunate errors, those errors go into even misquoting what the law says, brings very serious questions to the fore as to whether or not the public protector herself is on a frolic of her own, whether or not she's got sufficient support in terms of consultation within the office, or whether or not this is indeed a reflection of the competence or lack thereof of the entire office.
So if one is accused in a judgment of being irrational and reckless, does it point to a deliberate action to obfuscate the law and the spirit thereof?
It's important to distill the wording that is used. So in administrative law, And in review cases such as this one, the Promotion of Administrative Justice Act allows that wording to be used or for decisions to be set aside on the basis of irrationality, on the basis of illogic, conduct, on the basis that you took irrelevant considerations. So the language of the area of law that we're dealing with actually does allow for this. So this is not out of the ordinary. So the language that is used is not a personal attack. But I'm just saying,
what are the implications thereof? Because considering that there are efforts underway that are calling for her removal on the basis of competence.
Sure, the implications are dire. I mean, this is exactly this is the last thing that the public protector needed. If you think about the accusation that she made against the president on money laundering, where there was absolutely no evidence to come to that conclusion, also brings into question, what remedies can lie, for the president in pursuing other causes of action, around that. So this definitely is, I would like to say, the last straw, if you like.
Just very quickly, is it the last straw, or can she appeal, and perhaps successfully?
Look, the law does allow for reviews to be appealed, and that appeal would have to be, to the Constitutional Court. This was a full bench decision that was handed down by Judge Madojane. So nothing in law stops her from appealing, but if...
It makes it unlikely.
Yeah.
All right, thank you so much. Bulelwa Mabasa is director at Werksmans Attorneys. Let's take you back to Aldrin.
I said you can't.